My dear friends, today I am taking 8th question of 5th semester K5001. My dear friends, what is 8th question? What do you know about the inherent power of the court, under what circumstances it is to be exercised? Inherent power of the court. This is the most important question. There are two types of power in the court. One type provided by the court, and second type, that is inherent power. Due to the obligation of the judge or due to the duties of the judge, this power is inherent of the judge power. My dear friends, what is definition of inherent power? The inherent power of the court are in addition to the power conferred on the court by the court. They are complementary to the court powers, and the court is free to exercise them for the ends of justice or to prevent the abuse of the process of the court. My dear friends, as I have told you, there are two types of power. One type provided by the court, second type of the inherent power of the court, provided not by court but itself in the court. So for the justice, these two powers can be used. First, judge will use the court power, and if there is a need of extra power, that is inherent power, he can use this power for justice. The reason is obvious. The provision of the code are not exhaustive. It means the provision of the code, or you can say the power of the codes, are not sufficient to make the justice, for the simple reason that the legislature is incapable of contemplating all the possible circumstances which may arise in future litigation. My dear friends, the inherent powers are the complementary powers. Inherent powers are the additional power, and these power can be used in exceptional cases or in exceptional circumstances. So inherent power come to rescue in such unforeseen circumstances. They can be exercised in the absence of provision in the court. Some circumstances may appear before the judge that the power of court will not be applicable there. There, judge can use the inherent power, or you can say the judge power, yeah, or his own power. This is the real definition of the inherent power. Now, I am taking more definitions of this inherent power. My dear friends, as I have said that I will give more definitions to clarify the inherent powers. As I have defined, for justice there is a need of two types of powers: code power and inherent power. And according to Raghuvar Dayal Justice, he said, he stated the inherent power has not been conferred upon the court. It is a power inherent in the court, as I have said before this. This power is inherent in the court, not conferred by the other agency or court by virtue of its duty. to do justice between the parties. So for do to do justice, there is a need of two powers: court power and inherent power. Court power is provided by the court, and inherent power is already exist in the court. This is the power of the judge only. So here say there are 2 points. This power is necessary in the interest of justice. Here is, I am again defining this. This power is necessary in the interest of justice. The inherent power has its roots in necessity. When there is a need, when there will be a need, then it is used. Inherent power is used in the need or in the necessity, and its breadth is coextensive with the necessity. So its jurisdiction, you can say, breadth means jurisdiction according to the necessity in the judgment. I am giving one example, my dear friends. I was a lecturer of mathematics. So in mathematics, inherent power is called complementary power. And see here in mathematics, for 90-degree, if we have an angle of 80-degree, there is a need of 10-degree to complete a right angle. Right angle is of 90-degree. This 10-degree is added with the 80-degree to complete the 90-degree. So this is complementary angle. So inherent power and court power both are, with the help of these powers, you can get the justice. So court power comes under 80% and inherent powers comes under 10%. And this is complementary angle. These powers are complementary power. So by this example, it is, I think, more clear to you. I am taking next circumstances. My dear friends, I am taking, after the definition of inherent power, the circumstances in which this power is used. I am taking the circumstances one by one. The circumstances under which inherent power is used. This power is used under section 142, 148 to 152 minus 150 and 153A of the code. Enact the law relating to inherent power of the court in different circumstances. This power, these codes, these sections are about the inherent power which enact the law relating to the inherent power of court. Now first, I am taking one by one the circumstances. In what is the first circumstances? Extension of time. If the time of the justice has expired, in that case, judge can extend the time. This is due to the inherent power. Here you see, section 148 provides that where any period is fixed or granted by the court for doing any act, the court has power to enlarge the said period even if the original period fixed has expired. If a court in exercise of the jurisdiction can grant time to do a thing in absence of the specific provision to the contrary, curtailing, denying, or withholding such jurisdiction. My dear friend, This is clear by this definition. Time can be extended if time is fixed by the court or the procedure of the court. So, in that case, time can be extended or time can be enlarged by the judge. This is the definition. Original fixed time has expired. In the exercise of jurisdiction, can grant time to do a thing. It means the main motive of the judge is the justice. So, for the justice, judge can use this inherent power to extend the time. This is the first case. My dear friends, second circumstance, payment of court fees. Section 149 empowers the court to allow a party to make up the deficiency of court fees if there is payable on a plaint, even after the expiry of the time of limitation prescribed for the filing of such suit or appeal, etc. Under Section 4, it is prohibited no court fees, and if there is no court fees, no suit. Or you can say no plaint can be submitted in the court. So, this power is given to the judge to extend the power of the payment of court fees. And this power, which is extended by the judge, is known as inherent power. So, this is the second condition, payment of court fees. If there judge feels such a circumstance in which the payment is short or there is a deficiency in the payment, judge can allow the payment should be made immediately. This is due to the inherent power. Third, end of the justice. As I have said, my dear friends, for the end of the justice, this inherent power is used because court powers are not sufficient to get the end of justice. This inherent power is also used by the judge in some circumstances. So, this is the end of justice. Third circumstance, in which court powers are not sufficient, a judge can use extra power to get the end of justice. This extra power is called inherent power. So, I am taking fourth. My dear friends, I am taking fourth circumstance in which the inherent power is used, abuse of the process of the court. The inherent power under section 151 can also be exercised to prevent the abuse of the process of the court. Such abuse may be committed by a court or by a party. If any court employee does this abuse of process, the court may correct its miscarriage or misdeed done by the court itself. So the justice done for the party must be remedied on the basis of this act and shall prejudice no one. Here, by this definition, it is clear, my dear friends, if any abuse is done in the court from the court employee's side or from the party side, it can be remedied by the court itself by his own motion or by others' way. So, due to this inherent power, this can be done. Otherwise, the court power does not allow to do this or to make this correction. Only the judge power, which you can say the inherent power, can be used to do this work. Fifth, amendment of judgment, degree, order, and other record. What is type of this amendment? My dear friends, when the court is in working order, some clerical or arithmetical mistake may be. It is possible these mistakes can be anywhere. The judgment, according to section 152, says that clerical or arithmetical mistake in judgment, maybe in the judgment or in writing, degrees or orders or arising from any accidental slip or omission may of any time be corrected by the court. And any time this can be corrected by the court, either of its own motion or on the application of any of the parties. If this mistake is found in the court, whether it is intimated by the party or whether it is intimated by any other official of the court, this mistake can be corrected within the time under this inherent power, either of its own motion or on the application of any of the parties. This is the fifth condition. Now I am taking sixth. My dear friends, I am taking sixth condition under which the inherent power is used. Although it is true that the inherent power of the court are very wide and they residuary in nature, and they are in addition to the power conferred on the court by the court. Yet these inherent power can be exercised only in the absence of the ex provision in the code. They cannot be exercised in the conflict with what had been expressly provided in the code or against the intention of the legislature. My dear friend, I have defined 2 or 3 times before this. This inherent power cannot be used against the court. The powers given by the court to the court against the court, these powers cannot be used. Or these powers cannot be used against the legislature. So, these powers can be used only in the absence of these powers by the code or by the legislature, and where it is needed in the court so that the justice may not be delayed. In that circumstance, this power can be used. This is the limitation. What is meant by limitation? Court is bound, the judge is bound, cannot use these power against the code power, against the legislature power. This is, there should be no confliction. If there is any conflict with this provision, expressed provision, then these powers cannot be used. Again, in the last, the inherent power are to be exercised. The inherent power are to be exercised by the court in very exceptional circumstances. This is the condition. These powers can be used in very exceptional circumstances, not everywhere. Thus, the court can use inherent power not against section 10. This section is very important. Section 10. this power cannot be used against this section S10. So this is the condition when the inherent powers are used. This section is to be taken into consideration. My dear friends, I have taken this question, definition of inherent power. I have defined this inherent power so widely, and the circumstances, there are 6 circumstances in which the inherent powers are used or not used. These 6 circumstances I have mentioned one by one in detail. So I think the concept of this question is clear to you. I shall be, in the last, I want to make a request to you. Please subscribe the channel. I shall be very thankful to you.